HIV infection and contract with football players. A decision of the High Court of the Canton of Zurich, which had been taken on 8 April 2013, yet surfaced to public discussion only recently, has brought or should bring the possible legal implication of very serious disease, and in particular of HIV infection, back to the attention of international sport lawyers. This implication may arise not only in professional football but also in all comparable sporting disciplines. Michael Bernasconi, newly appointed member of the World Sport Law Report editorial board, and Dr. Jan Kleiner of Bar and Career AG provide an analysis in light of a aforementioned court decision of the contractual issues that an HIV infection raises both before and after the conclusion of a contract between a football player and club, and in particular assess the situation faced by the court, which had to examine the legal validity of a unilateral termination of an employment contract by a football club related to an HIV infection of a professional football player. It was almost 25 years ago, during the NBA season 1991, that the great U.S. basketball player Irvin Magic Johnson Jr. was tested positive for HIV during a standard medical check. At that time, HIV infection of top athletes reached the front page of all the newspapers. Since then, beside of a few exceptions, HIV positively has hardly been the topic of high-profile cases of professional football players or other athletes, at least as far as publicly known. Rather, heart failures have been at the center of the media's attention recently in connection with the terrible event of April and May 2015 concerning two young Belgian players, Gregory Martin and Tim Nyket. Against this background and triggered by the above-mentioned court decision, this short article will focus on the contractual issues that an HIV infection raises before a contract between a player and a club is concluded on the basis of the regulatory obligation and rights of professional football players and football club in accordance with the FIFA regulation on the status and transfer of players after the conclusion of a contract, in particular in cases where a party wishes to prematurely terminate such contract. HIV test and conclusion of agreement. According to Art 18, Viva RSTP, the validity to a contract may not be made subject to a successful medical examination and or the grant of a work permit. As the title itself of Art Viva RSTP reveals, the contractual relationship which is regulated by Viva RSTP is the one between a new club and a professional football player. Accordingly, and without commenting on the economic viability of such a contractual solution, the validity of a transfer agreement between two clubs can be made subject to successful medical examination. Apply it to case of HIV infection, the meaning of Viva RSTP is clear. A football club cannot conclude an agreement with a new player and make such agreement subject to, among other possible tests, a HIV test to be performed after entering the agreement with the player. In other words, if a club decides to sign a new player and to perform medical and HIV tests only after signature, the club cannot agree with the player that a negative HIV is a condition of validity to the agreement. Accordingly, under the FIFA RSTP, if a club discovers after conclusion of a contract with the player that this player is HIV positive, the club will in principle not be able to argue that the employment contract was invalidly concluded. Assuming, therefore, that the agreement between club and player will be valid, the question arises whether such agreement can be prematurely terminated. HIV test and termination of agreement. Mutual agreement. Under the FIFA RSTP, agreement between club and professional players may only be terminated upon expiry of the term of the contract or by mutual agreement. A first possible modality of termination of an agreement between a club and a professional player, therefore, is to reach a consensus and conclude a valid mutual termination agreement. Thank you.